What are the latest XRP news? How much will XRP cost after the trial? When will the result of the trial be announced? We will answer all these questions in today's video. The crypto world is coming to the conclusion that the lawsuit between blockchain startup Ripple and the Securities and Exchange Commission, SEC, is just around the horizon. The decision of the lawsuit is likely to have a significant influence on the regulatory trajectory in the crypto markets, particularly on securities categorization. In the most recent update, pro-Ripple lawyer John Deaton predicted in a tweet on March 27 that the judge's decision will be issued within the next several weeks or possibly this week. According to Deaton, if the SEC prevails, there may not be much downside for XRP, since the coin has the best risk-reward ratio. Yet, if Ripple prevails, it will be evident that XRP is not a security, and the token will have an upside. A Fox Business article said that attorneys working on the case believed that the legal disagreement might be resolved in the coming days, raising the likelihood of a summary judgment date. Deaton, who thinks that the disputed Heinemann speech emails will be disclosed because they are judicial papers, has pushed the crypto community to see the lawsuit as an assault on the whole digital asset market, rather than just Ripple. In another development, defense lawyer James Phelan tweeted on March 23 that the SEC had submitted its answer to the Ripple defendants' papers requesting supplementary power based on the Bittner and Voyager cases. The letter included throwaway observations, paragraphs from the judge's concurring judgment in the Bittner case, and a bankruptcy plan confirmation order from the Voyager case, according to the SEC's response. It goes on to say that the defendants argue that the extracts support their fair notice claim, which the SEC disagrees with, and that there is no reason to reject the SEC's summary judgment request. In this vein, Ripple supporter lawyer Jeremy Hogan said that although the SEC's answer makes legitimate concerns regarding the Bittner case, the regulator's effort to argue against the Voyager judge's finding on the perceived uncertainties of the crypto sector is smirkable. He went on to say that, although the response overturns the Bittner verdict, the Voyager judge's decision still stands for Ripple. With both sides confident in their ability to win the lawsuit, one noticeable result has been the possibility of a settlement. Nevertheless, according to Australian lawyer Bill Morgan, a review of the SEC's response letter eliminates the likelihood of a settlement. While the court battle between Ripple and the U.S. Securities and Exchange Commission, SEC continues, the regulator has submitted its response to the blockchain company's claims, which relate to previous legal issues and their conclusions that may have an influence on the cryptocurrency business, according to a tweet posted on March 23 by U.S. defense attorney James K. Phelan. The SEC has submitted its response to the two letters regarding supplemental authority from the bankruptcy case of the cryptocurrency lending platform Voyager Digital, as well as the Bittner v. United States case before the U.S. Supreme Court. Previously, Ripple's legal team filed the Voyager bankruptcy case ruling as a supporting reason for its fair notice defense, notably Judge Michael Weil's observations on the significant uncertainties in the crypto industry on which regulators themselves cannot seem to agree. Meanwhile, the second letter is about the Bittner v. United States case, in which a dual Romanian-American citizen refused to record all of his income. According to the judgment, due notice should be provided to the public in terms that the common world would comprehend of what the law plans to do if a specific border is crossed. According to the SEC's response, the defendant's claims in these letters do not hold water in the fair notice defense and neither offers any reason to reject the SEC's petition for summary judgment. The letters include stray statements from two instances purportedly in support of the defendant's argument to the SEC's petition for summary judgment. The defendants argue that both portions support their fair notice claim, but neither does. The SEC's legal team asserted in its reasoning that the Bittner case concerned whether a penalty could be imposed once for each unreported foreign bank account or as a single fine, and that it was concluded that the rule of lenity allowed a single penalty for the transgression, but that the court's decision did not imply it could be used to escape liability. Defendants blatantly mischaracterize the Voyager Bankruptcy Court's comments and select chosen terms out of context in a misguided effort to strengthen their unavailing affair notice claim, the SEC stated of the Voyager case. Nowhere in its ruling did the Bankruptcy Court highlight any alleged limited instruction offered generally to market players or even imply that it extended outside of the particular action at issue. Former lawyer and Evernote XRP co-founder Scott Chamberlain previously listed potential outcomes for the lawsuit, including summary judgments, a settlement between the parties, and a subsequent case to investigate whether any of the XRP token sales in the United States included an unregistered investment contract. Notably, his suggestions came after Ripple, in his opinion, scored a major victory against the SEC with a fatal exclusion of one specific witness, as Judge Annalisa Torres issued an initial 57-page ruling in which both the blockchain company and the financial regulator sought to exclude expert testimonies from summary judgment. Ripple Chief Legal Officer Stuart Alderoty responded to Coinbase's SEC Wells notification. SEC. A Wells notice is a SEC letter stating that a corporation or person violated securities laws. It gives the receiver 6 months to refute these charges before the SEC decides to take action. Coinbase received this SEC letter yesterday. According to Coinbase's chief legal officer Paul Grewal's blog post, the warning gave Coinbase nothing to react to. The statement claims that an undefined part of the exchange's tradable assets, Coinbase Prime, and its self-custody wallet violate investor protection regulations. The crypto exchange was investigated last year. In a case against former Coinbase employee Ishan Wahi for insider trading, the regulator also alleged that 9 exchange assets were unregistered securities. Coinbase still trusts their asset listing procedure. Coinbase does not list securities, Grewal said in the blog yesterday. In recent weeks, the crypto exchange has also asserted that its staking program is not an unregistered securities offering. In February, Coinbase rival Kraken settled SEC allegations by permanently ending its U.S. staking operation and paying a $30 million fine. Coinbase notes that the SEC authorized its operation and permitted it to become a publicly listed corporation in April 2021, days before SEC Chair Gary Gensler took office. In the previous 9 months, the company met with SEC investigators 30 times to register part of its operation and settle inquiries. Although Coinbase paid millions in legal expenses to identify viable registration models for Bitcoin, the SEC stopped the process in January. Grewal speculated that Gensler's numerous remarks urging crypto businesses to register with the SEC would fail. As reported in recent months, the crypto exchange seems to have been preparing for a showdown with the regulator. The crypto exchange recently revised its risk statement to clarify that it may not remove a listed crypto asset even if the SEC labels it a security until the regulator wins in court. Ripple is still fighting the market regulator on whether XRP is an unregistered securities. The blockchain payment startup got an amicus brief from Coinbase in its battle against the whole fledgling industry. If the SEC takes action, Consensy's lawyer William Hughes expects a flood of amicus filings supporting Coinbase. Alderoty's responses and history suggest Ripple might support Coinbase. Hughes believed that if the SEC enforces, the court fight would go years and beyond Gensler. The attorney predicts that factual issues will lead to appeals. In July, CryptoLaw founder attorney John E. Deaton called the SEC a complete and total disgrace. The regulator's actions angered and grieved the attorney. The attorney later tweeted that free marketeers would be disgusted by the SEC's actions. U.S. market growth is questionable. Once Terra and Fox collapsed, authorities, notably the SEC, seem to have initiated an industry-wide crackdown. Market players want unambiguous instructions.